So if for some reason you can't stay for the whole thing, but you better, or you just want to share this afterwards because you loved it so much, which is probable, you can go to the Politics and Prose YouTube page and find this as soon as we're done. All right. Well, yeah, we can get going now. Hello and welcome to Politics and Prose Live. I'm Alan Watkey, Deputy Director of Events at Politics and Prose. Thank you all for joining us today with celebrating Scott Seligman's new book, the launch of his new book, A Second Reckoning. At any point during the event, you can click on the link in the chat to purchase a copy of A Second Reckoning on the Politics and Prose website. You'll be able to ask Scott a question by clicking on the Q&A link, which can be found near the bottom of your screen. We'll get to the audience questions towards the end of the event, and we will try to get to all of your questions, but apologize if we run out of time. I also want to let you know that closed captioning is available for this. If you click on the CC link right next to the Q&A box, you can enable that. And now I want to thank Scott Seligman and welcome him to Politics and Prose Live, celebrating the launch of his new book, A Second Reckoning, Race, Injustice, and the Last Hanging in Annapolis. A Second Reckoning tells the story of John Snowden, a Black man accused of the murder of a pregnant white woman in Annapolis, Maryland in 1917. He refused to confess despite undergoing torture, was tried, though through legal shenanigans, by an all-white jury and was found guilty on circumstantial evidence and sentenced to death. Despite hair-raising last-minute appeals to spare his life, Snowden was hanged for the crime. Decades after his death, thanks to tireless efforts by interested citizens and family members who believed him a victim of illegal lynching, Snowden was pardoned posthumously by the governor of Maryland in 2001. Seligman uses Snowden's case to bring posthumous pardons to the national conversation about amends for past racial injustices. He argues that the repeal of racist laws and policies must be augmented by reckoning with America's judicial past, especially in cases in which prejudice may have tainted procedures or perverted verdicts. Evidence of bias survives and a constituency exists for a second look. Seligman illustrates the profound effects such acts clemency have on the living and ends with the siren call for a reexamination of such cases on the national level by the Department of Justice, which officially refuses to consider them. Scott D. Seligman is a writer and historian. He is the author of numerous books, including The Great Kosher Meat War of 1902, the award-winning The Third Degree, and The First Chinese American, The Remarkable Life of Wang Qingfu. And so now, please welcome to PNP Live, Scott Seligman. Hello and welcome, Scott.
Thank you, Alan. Let me share the screen here for just a second and get started. Okay, are we good? Can you see the slides?
Nope, not yet.
Okay, then I screwed it up. Give me 1 second here. Share the screen, share, and how about now?
There you go.
Okay, we're good. Great. Well, first of all, I want to express my gratitude to Politics and Prose. This is the 4th book, I believe, that I've launched here. I only live a few blocks from the Connecticut Avenue stores. I'm luckier than most people because I've got this treasure in walking distance. And I'm very happy to support an independent bookstore with a commitment to the neighborhood. You know, on the one hand, it's sort of a shame that we aren't able to do book talks in person right now. But on the other, making it virtual actually means, first of all, people don't have to be in Washington to come. It's also safer and more convenient, and you know, you don't have to get dressed to listen. So you know, 6 of one, half a dozen of the other. I'll talk for about maybe 25 minutes today, and then I'd be very happy to take questions. Most of my published works have had something to do with the early history of what you might call hyphenated Americans. I've written 4 books on Chinese American history and 1 on Jewish American history. And it was one particular book that's called The Third Degree. It's the one you're looking at on the slide now, that got me interested in how minorities have historically been treated and too often mistreated by the legal system. Now, John Snowden, which the new book is about, doesn't appear in this book, which was published in 2018, but it's actually about a case that bears some similarity to his. It told the story of a Chinese man named Jiang Sengwan, who was accused of murder here in Washington, D.C. in 1919. He was abused during his interrogation. He confessed under duress, but recanted the confession at trial. And the issue of whether his confession should have been thrown out of court actually landed the case in the Supreme Court. And in the court's ruling, which was written by Justice Brandeis, it set America on the road to what would eventually become the decision that conferred Miranda rights on all those arrested, even though it was a couple of decades before the actual Miranda decision. Now, John Snowden's case occurred at almost exactly the same time. It was 1917. Both of them involved minority defendants that were subjected to abusive treatment by the police, and both men were initially convicted. But one who actually did confess was eventually released, whereas John Snowden, who didn't, was hanged. Well, the story begins when 2 newlyweds, Lottie Mae Brandon and her husband Valentine, moved to Annapolis from Washington, D.C. in 1917. Valentine had a job at the Naval Experiment Station in Annapolis, just across the Severn River from downtown Annapolis. And Lottie Mae was pregnant with what was going to be their first child. She was not working. Housing was very difficult to find because it was the war. It was World War I, and a lot of people converged on Annapolis during the war. But they managed to find a place on a flat on 2nd Street, which today in Annapolis is called Lafayette Avenue. And here's actually a picture of it. The building does not exist anymore. On the other hand, the building on the right, which was then and still today is the parsonage of the Asbury United Methodist Church. So I've been on that street measuring things and walking up and down several times. So on August 8th of that year, when Valentine returned from work, he found Lottie Mae motionless on the bed. He ran for help, but she was discovered to have been murdered, to have been brutally murdered, actually, at about midday that day. There were no suspects, no obvious suspects. The police first suspected Valentine himself, but he'd been away at work all day. She had been seen after he left from work, and he really had an airtight alibi. So the police, after they interrogated him for several hours, they decided he probably was not responsible for the death. Now, Annapolis didn't have detectives in those days. It just had police. So when something like this happened, they would send to Baltimore for the detective squad. And these reinforcements for Baltimore, Baltimore sent 3 people. Those are the men you're looking at right now. They were regarded as what they called the best 3rd-degree men in the country. And among the 3 of them, they had sent a couple of dozen men to the gallows and many, many more to the penitentiary. They had a reputation of being able to break people who didn't want to confess. But they were stumped. And after several days, they questioned everybody they could find, everybody they could think of in town, but they really were lost, and they admitted it to the press. They were nowhere several days later. It was not clear which direction to go, and they really didn't have any suspects. But this was Annapolis in the Jim Crow era, and it didn't stop people from jumping to conclusions. Without a shred of evidence, the editor of the Evening Capital, which is the ancestor of today's Capital Gazette, she concluded that the crime had been committed, quote, evidently by a Negro. There was absolutely nothing evident about it. They had no clues. They didn't know who had done it, but she decided that it was probably a Black person. And that's kind of what was going on in Jim Crow, Maryland. There was a man named Philip Brown, who was a local activist much later. He wrote a book in 1994 called The Other Annapolis. And the quote that stood out for me in his book was, there were 2 groups of people living in one geographic area, but living altogether separate and different lives. And you didn't need facts or evidence to lob a grenade across the color barrier back then. It didn't take evidence to decide that a black person had probably committed the crime, and there was none at this stage. Well, it went on for several days. Eventually, there was a break in the case. This is a contemporary photograph that I took. This is a house right across the street from where the Brandons lived. And it was the home of Edith Credit and Mary Perkins, who were two sisters. They were black women who lived across the street from the Brandons. And which actually was surprised me initially, because having written about Washington, D.C. in this era, I was used to segregation. But Lafayette Avenue, or rather 2nd Street, was completely integrated back in 1917. There were whites and blacks living cheek by jowl, and they knew each other and they interacted with each other. Annapolis, I gather Annapolis was really just too small to have been able to accommodate that kind of segregation. But these are two black women. They lived across the street from Lottie Mae Brandon and Valentine Brandon, and they came forward after several days. They said they had seen a man leave the Brandon home at around the time that the coroner believed the murder had taken place, which was midday. And they could identify him. He was an Iceman, a black Iceman named John Snowden. They said they had not come forward earlier out of fear of a race riot. And indeed, they had been advised by several prominent black people in the community that this sort of thing actually could lead to a race riot. But they knew, and they had information about the man that all Annapolis was looking for. And so finally they came forward. So the police went immediately to arrest John Snowden. He didn't resist. He didn't even ask why he was being arrested. And they interrogated him for several hours, and then they transferred him to Baltimore. Why Baltimore? Because in 1906, in Annapolis, a black man named Henry Davis, who was suspected of the attempted rape of a married white woman, had been dragged from the jailhouse in Anne Arundel County in Annapolis to a vacant lot, strung up and shot to death by white vigilantes. Even though the county had built a new fortified jailhouse since that time, the police weren't taking any chances with a lynching. There was a lynching in recent memory. They didn't want something like that to happen again. So they spirited him off to Baltimore into police headquarters. And in Baltimore, John Snowden was interrogated incessantly, and I believe physically abused in order to extract a confession. But he maintained his innocence and refused to confess. However, even without a confession, though, the investigation turned up very powerful circumstantial evidence against him. First of all, he lived on Acton Lane, which you see in the slide there, right behind the Brandons. And the woman that he lived with occasionally did laundry for them. So there was a relationship between the two households. He had not gone to work on the day of the murder. He could not satisfactorily account for his actions that morning because he'd been drunk the night before. He had been seen outside the house, as I mentioned, by two credible witnesses. He had been caught in several inconsistencies during his interrogation, and there were scratches on his face. And that was significant because once the autopsy revealed that Lottie Mae Brandon had skin under her fingernails that had belonged to an African American, the police decided they had their man. They stopped looking for anybody else. So here's the Reader's Digest version of the story. Snowden was tried and he was convicted. His attorneys appealed, but the appellate court sustained the verdict. The Chief Justice of the US Supreme Court declined to review the case. And the governor of Maryland at the time, Emerson Columbus Harrington, even though he was lobbied hard for clemency by whites and blacks alike in Annapolis, he refused clemency and John Snowden was hanged for the crime. But that was not the end of the story. The Snowden case was regarded for most of the 20th century by many people in Annapolis, especially the black community, but not limited to the black community, as an example of what they called a legal lynching. And kids grew up and they heard the story of John Snowden all through the century. This crime was not forgotten. Now, fast forward with me to the 1980s, and I want you to meet Carl Snowden, a sometime alderman in Annapolis, who also held positions with the state and with the county. And when John was campaigning in the early 1980s, he ran into John Snowden. And by the way, he's no relationship, same surname, no relation to John Snowden, as far as anybody knows. He ran into John Snowden's brother, Lewis, who in that point was in his mid-80s. And Lewis told him John's story, and it stayed with him. Carl is a student of history. He didn't need much persuading that John had been denied justice in Jim Crow, Maryland. He was well aware of the indignities that Black people had suffered in that period. And over the period of a decade, Carl petitioned 2 governors of Maryland to reopen the Snowden case. Finally, working with a small group of local activists and Snowden family members, he got the attention of Governor Paris Glendening, who eventually granted John Snowden a posthumous pardon in 2001. Now, in reviewing the case, and I was very fortunate that although some of the records are gone, much of the trial transcript actually survives. I realized that there was really no way that guilt or innocence could be established conclusively a century after the trial. Even Glendening did not declare John Snowden innocent of the crime, although many people believe he was. I knew that I would never be able to be certain. And so I walked away for a while. I worked on a different book. But something about it kind of grabbed me and I came back to it. And then it dawned on me that maybe I was asking the wrong question. Whether he was guilty or not, had he been treated fairly by the judicial system? And that was a question I felt I was in a position to explore and possibly to answer. And in doing the research, I concluded that he had not. And I'll tell you why. Now, Maryland was not the Deep South, and John Snowden's treatment in court was certainly an awful lot better than that accorded to the Scottsboro boys. You may have heard of that case. That was 9 black teenagers in Alabama in 1931 who were accused of raping 2 white women. These guys were never told they had a right to counsel. They were given no advance access to their attorneys. They were sentenced to death in rush trials that lasted 1 day. Now, none of that happened to John Snowden. He had a qualified attorney who defended him and who fought hard for him, as far as anybody can tell. And on the surface of it, one might think that his treatment by the system was a fair one, but not if you study the details. Snowden's trial began in Anne Arundel County, where the crime had taken place. But after 11 jurors had been impaneled, the prosecution ran out of challenges. The law in those days was that in a case like this, the prosecution was allowed 10 challenges to jurors, but the defense had an unlimited number of challenges. So they have impaneled 11 jurors, and they are in the process of interviewing a possible 12th juror when the state's attorney, a man named Nicholas Green, suddenly insists without explanation on a change in venue. Now, actually, people had speculated before the trial began that it would be the defense that would ask for a change in venue, because after all, the murder had occurred in Annapolis, but the defense never asked for one. It was the prosecution who did it, and the prosecution did it very suddenly and without explanation. So I did some analysis. In those days, they published the names of the jury pool. And this was 1917, so I took a look at the 1920 census. And I concluded that the 11 people who had been chosen were almost assuredly, almost certainly, all white. The names of those left in the jury pool were never actually published, but if one of them had been black, the state's attorney would not have been able to prevent him, and it had to be a him. There were no women on juries until 1947 in Maryland. The state's attorney could not have prevented him from being chosen. And the same is true if there was a white person on the jury that the state's attorney had reason to think might be sympathetic to John Snowden. So what happened, I think, is that Green decided to roll the dice a second time. And they negotiated for a while, and they decided ultimately to move the jury trial to Towson. Now, what Green did would not have been against the law at the time. It was still legal in 1917 to keep a person off of a jury because of his race, and actually would remain illegal until 1986. But it would have been motivated by racial prejudice. But if there had been no blacks at all in the jury pool as a result of a deliberate effort to exclude them, which may well have happened here, and that actually seems more likely to me, that would not only have been a product of racial bias, it would have been unconstitutional even then. There was a Supreme Court case in 1880 that held that categorical exclusion of by race from a jury pool was a violation of the Equal Protection Clause of the 14th Amendment. Today, both of those scenarios are deemed to be, are understood to be unconstitutional. Well, it seems obvious in hindsight that what the prosecution was doing was he was shopping for an all-white jury, and that's what he got in Towson. Another issue was Snowden's treatment during his interrogation. Although the police denied it, John Snowden insisted, and he testified under oath, that during the course of his various examinations, and there were half a dozen of them, he had been repeatedly threatened, stripped, knocked down, forced to his knees, pummeled, struck over the head, made to drink whiskey to get him drunk, and actually had a loaded revolver pointed at him. Now, the police denied all of that, and that gave the judge a pretext on which to accept in evidence everything he said during his interrogation. But if any of it were true, of course, nothing that he said during his interrogation should have been admitted by the court. But the judge ruled it all admissible. And here's the judge. He was Frank Duncan. There were also many instances where Duncan ruled against the defense that were, I would say, are highly questionable today. For one thing, he didn't permit the defense to impeach the credibility of the two sisters who came forward and identified John Snowden, even though they had actually not come forward until a $500 cash reward had been offered. He permitted the results of an autopsy to be introduced in evidence. Actually, there were two autopsies. They did one the first night when the body was discovered, but then there was pressure to see if maybe they had left some stones unturned. So they did a second one. And the second one was conducted only after the body had been handled by two undertakers, was in the custody of the victim's husband to get it back to Washington. And of course, he had been a suspect. It was fingerprinted by the DC police. It was transported to the Brandon home for a funeral. It was buried for several days, exhumed, and then they performed the second autopsy. And that's when they discovered the particles under Lottie Mae Brandon's fingernails. But clearly, it was very important to the defense to get that thrown out because that evidence was quite damning. But the judge let it in. He also permitted testimony related to rape. Although there was some evidence of sexual activity on the body, it was not conclusive, and John Snowden was never charged with rape. The testimony was inflammatory, shouldn't have been allowed, it was allowed. The judge also allowed the prosecutor to make some prejudicial statements during his summation. For example, and here's a direct quote, "The Negro who ravishes a white woman deserves the extreme legal penalty and nothing short of it," end quote. Well, it was wrong not only because it was racist, but also he was asking the jury to send a message rather than focusing just on the facts of the cases, which is what they were supposed to be doing. I think the case of John Snowden demonstrates that there are many ways that justice can be denied that are far more subtle, but just as nefarious as railroading hapless defendants through a racist kangaroo court. And then there was the governor of Maryland, who was in a position to commute the sentence or issue a pardon. He proclaimed himself very loudly to the press. He said, "I am a friend of the colored race." But he justified declining clemency to John Snowden because, and here's another quote, "I had recently refused to commute to life imprisonment a colored man guilty of rape upon a colored girl. So he said he could hardly do so for, quote, a Negro who has committed, in my opinion, both murder and rape upon a white woman," end quote. Well, now why mention races of the people if races weren't important to him? Of course they were. And why talk about rape? He hadn't been charged with rape, but still in all, it was within his jurisdiction to decide whether or not to offer clemency, and he decided not to do it. So, Carl Snowden, come back to the 1980s with me again, is surely one of the heroes in this story. Carl is well known around Annapolis as an ex-government official and an activist. He actually went through two gubernatorial administrations looking for clemency for John Snowden before he found one who would do it. He started with William Donald Schaefer, Glendenning's predecessor, and Schaefer had run on a law and order platform. He believed in capital punishment. He wasn't interested. Even Glendenning was a proponent of capital punishment, but he's the one, as John Snowden said to him, with the stroke of a pen, you can correct this injustice. And that's just what Glendenning did, 80 plus years after the fact. He took no position on John Snowden's guilt or innocence, but he did conclude that there was substantial evidence that he hadn't been granted a fair trial. And I wound up in more or less the same place, although frankly, I think I found more things to object to in the record than Glendenning did. Another heroine in this story is Hazel Snowden, John Snowden's niece. Now, Hazel never met John Snowden. She was born many years after he died. She was the daughter of Louis Snowden. And she also joined the lobbying effort. She attended meetings, she wrote letters, she phoned the parole board, she wrote the governor personally. And the evening that the pardon was issued, Hazel went to the grave of her uncle at Brewer Hill Cemetery to pray for his soul and to weep for him. She was very, very moved by the whole thing. And this kind of gets to why I wrote the book. Posthumous pardons obviously do no demonstrable good to the dead. They're clearly all about the living, usually relatives or friends of the deceased like Hazel, but also their spiritual or political heirs or just people who are moved by their cases like Carl Snowden. Pardons are, of course, most valuable when they redeem the living. And living prisoners should, as far as I'm concerned, should always go to the front of the line. But when they're applied to the dead, they can also be extremely worthwhile if they heal or if they send an affirmative message that the values of the past are discredited. They must not be the values of the present or of the future. Now, John Snowden's was a state level case, and almost all of the posthumous pardons in American history have occurred on the state levels. But in the course of my research, I discovered that when it comes to the level of federal crimes, the Department of Justice actually refuses to accept applications for posthumous pardons. And I think that needs to change. The policy is grounded in the belief that the department has very limited resources and they're better spent on the applications of living persons. And I don't dispute that. The Office of the Pardon Attorney has about 7 lawyers. Last year, they had a backlog of about 2,500 petitions for pardons and 12,000 more for other forms of clemency. So there's no questions that more resources are needed for this function and that living persons should always take priority. But the US government can multitask, and there can be great value in posthumous justice as well. First of all, the additional appropriations that they would need to address them, to bring on a few historians or attorneys who have a historical background, would be lost in the rounding. I mean, the Department of Justice annual budget is like $28 billion. And I think the government can walk and chew gum at the same time, given the paucity of posthumous pardons granted on all levels. There have only been about 175 posthumous pardons in all of American history, and only half a dozen of them were done on the federal level. They're all on the state level. So it's not like there are huge numbers of these kinds of cases. And the fact that most criminal activity in the United States is adjudicated on the state level would suggest that the burden would not be very heavy on the Justice Department. Well, a systematic investigation of all potentially racially tainted cases in the history of the country would surely be unmanageable. The list would just be too long. But the extent of America's racially injustice past also should not be an excuse to avoid revisiting it. At the very least, in cases where evidence of bias survives and where there's a constituency for a second look at a particular case. Here, I think some modern form of adjudication is not only desirable, I would argue it's imperative, and on both the state and federal levels. Now, I didn't write this book to advocate additional posthumous pardons for specific individuals. I'm agnostic on who should merit one and who shouldn't, but let me name a few cases that other people have suggested where racial prejudice may have played a role and that might be ripe candidates for consideration. We'll start with Marcus Garvey, a prominent Black nationalist known for his role in the Back to Africa movement. He was targeted by J. Edgar Hoover for his advocacy of civil rights, convicted of mail fraud in 1923, and ultimately deported to Jamaica, which is where he was born. Another one is John Anthony Copeland. He was part of the 1859 raid on Harper's Ferry, which he did alongside John Brown. And it was a rebellion to end slavery. He was hanged by the state of Virginia for his freedom fighting efforts, and he might be a pretty good candidate for, I think, some reexamination. Leaders of major slave revolts or suspected conspiracies, Gabriel Prosser, Charles Deslandes, Denmark Vesey, even Nat Turner would possibly be candidates. And then there were 2 men named that are referred to as the Oberlin rescuers, Charles Langston and Simeon Bushnell, one white, one black, one black, one white, I guess, convicted in federal court for violating the Fugitive Slave Act because they helped rescue an escaped slave from slave hunters. Another name that's been put forward is Geronimo, Native American warrior who fought white incursion on Apache land. After he surrendered, he spent the rest of his life at hard labor as a prisoner of the US Army. Well, in recent years, we've seen statues of Confederate generals torn down, and we've seen new names given to high schools named after slaveholders. Plus, over the years, Americans have eliminated many of the egregious discriminatory policies imposed by the executive branches of their state, local, and national government, and also repealed many of the racist laws, although we seem to have a problem with new ones coming in all the time. But those are only two legs of the stool. I think a moral nation must also reckon with its judicial past, especially cases in which prejudice is thought to have tainted verdicts, denied rights, perverted procedures. And I think historic miscarriages of justice should also be subject to a second look. Well, John Snowden was just as dead in 2001 as he was on the day of his hanging in 1919. His pardon was important to his family, which believed in his innocence, and more broadly to the Annapolis community, especially the Annapolis Black community, which in the main viewed his execution as a miscarriage of justice. And they expressed their gratitude to Governor Glendenning. Shortly after the pardon, he was invited to Asbury Church for essentially a celebration. And as he put it so eloquently at the time, this is one of the quotes that that stayed with me. He said, "The search for justice has no statute of limitations." And I think that's right. I think that's absolutely the case. Every year since that time of John Snowden's pardon, on or near his birthday, his niece Hazel has held a cookout in her uncle's honor. Friends, relatives, and other people who helped secure the pardon are invited. It's a celebration of his life, and it's a happy occasion, but it has its somber moments. Somebody is asked to read the text of the pardon aloud, and someone else recites John Snowden's last statement, which for a man who had about 6 months of education was soaring rhetoric, beautifully, beautifully written. And anybody who dismisses the value of posthumous pardons simply because they don't do anything for the defendant would do well to attend one of Hazel Snowden's barbecues. For me, they are eloquent testimony to the significance that such acts like posthumous pardons have for people who are very much alive today. Well, let me stop here. Because this isn't a traditional book talk, I can't exactly stop and sign copies of the book. But I can tell you that Politics and Prose has a supply of them that are signed. And if you want to buy one from them and you want a personalized inscription, just tell them, they'll call me, I'll walk up to the store and I'll be happy to sign a book for you. Or if you prefer, you can reach me through the book's website, asecondreckoning.com, drop me a note, and I'll be happy to send you a label that you can affix to the inside of the book. Well, now I'd be happy to see if I can answer any questions that you have, and let me unshare the screen and figure out how to do this. Let's see. Stop the share. There we are. Okay,
all right, Scott. Thank you. Yeah, thank you so much. That was fantastic. We do have a couple questions here. I want to encourage people to go ahead and go to that Q&A link right there at the bottom of your screen and put your questions in. I will also say, Scott, we have quite a few well-wishers in the chat. Lots of encouragement and congratulatory remarks.
Thanks to everybody for that. Yeah.
Absolutely. John Donaldson says, hi, Scott. Yeah. Hi, Scott. Really amazing. So there's a couple questions to this. We'll start with the first one. Do you know if any of the states, like the federal government, also refuse to issue pardons? Actually,
refuse is probably the wrong word, John. But there are a lot of states where no posthumous pardons have ever been issued. In most states, it's the province of the governor. There are some states that have a pardon review board that can make the decision. And actually, the Scottsboro boy case is an interesting one because apparently there had to be enabling legislation passed before they actually could issue the pardons. That was a state that didn't have a provision for posthumous pardons. but most governors have the right to do it. It's just a right that has been used very seldom. And your second question, they did not know. No, it's about the color of the skin. No, John, what happened was the first autopsy, they didn't check under the fingernails. They didn't know that there was skin under the fingernails. It was the second autopsy where it was discovered, and then it was examined and discovered to be what the doctors believed was the skin of an African American. So that's how that happened.
And then let's see. What similarities do you see in this case and some of the most recent cases of executions of Black men that have movements of stays? And then maybe thoughts on Julius Jones's case in Oklahoma?
Yeah, I'm not sure what movements of stays means, but clearly there are similarities. This kind of thing still happens. And we see it on television these days. I mean, John Snowden wasn't on television, but we do see this. I think there are similarities. I think that the history informs what's going on today. And that's frankly one of the reasons that I believe posthumous pardons are important. They're mileposts. They say, wait a minute, what we did in the past was wrong. And I think they arguably make it harder to do the same kinds of things in the future. And that's one of the reasons I believe they're important. Again, not because they help the person who's dead and buried.
And then Janet Shainberg asks, what has the reaction of the Black community been towards your book?
The Black community in Annapolis has been extremely supportive and very helpful. I interviewed some people, just asked what their impressions were of the case. And then Carl Snowden, Hazel Snowden, Janice Hayes Williams, a lot of people gave me the benefit of their time and their memories. People who had served, for example, on the committee that petitioned for a pardon. You know, most of my books take place in ancient history and everybody's dead. This was one of the first books I wrote where there were people who were active actors in the drama who were still alive. And of course, that's a mixed bag. If they're still alive, they can tell you you're wrong about something. When they're dead, they don't do that. But I was very pleased with all of the cooperation I got from the local Black community.
Wonderful. There is a couple in the chat. Judy Bayer, are there any women on your list of potential candidates for posthumous pardons?
Not on that list, but again, Judy, I don't really keep the list. That was a list I found written someplace else where other people had kind of written in. I'm sure there are women who are appropriate for this sort of thing. In fact, there are women who have gotten them in the past as well. Even though I didn't put anything on that slide, please don't take umbrage at it. I'm sure there are, and I'll do a little more research and see if I can come up with a couple and let you know.
Stacy Burden asks, what were John Snowden's last words?
Let me see if I can find that for you, Stacy. Because it's they were really moving. I'm not sure I can find it quickly. Give me a second. You would ask me a question where I have to do research. Okay, here it is. Just about there. Here it is. I'll read you just a paragraph or two. I've been in prison for 1 year and 6 months, and now I'm about to shake hands with time and welcome eternity. For in a few hours from now, I shall step out of time into eternity to pay the penalty of a crime that I'm not guilty of. I have been telling the truth ever since I was first arrested, but they tried to make me a liar. But God knows I am telling the truth, and after I have been hanged, I'm asking the authorities please to continue the search for the murderer of that lady, for I am not guilty of the crime. And if Gabriel should blow the trumpet to wake the dead, she would come forth and tell you so. Though I have suffered, it would have proved to the world that I was innocent. I would have willingly gone through that awful degree again. I wish I could have opened my heart to show you how pure and clean my heart is. And then the very end of it, he said, I'm leaving on the everlasting arm of Jesus, for I know Jesus died for all mankind. I could not leave this world with a lie in my mouth. And I found that very moving.
Absolutely. Another one in the chat, Stephen Mink. Scott, from your deep dive into available archives, Do you have any thoughts on what potential improvements are still to be made today in the documentation of legal processes for external parties to assess impartiality and fidelity to process requirements?
Can you repeat that? I didn't quite get the end of it.
Yeah. Do you have any thoughts on, whoops, it moved. Do you have any thoughts on what potential improvements are still to be made today in the documentation of legal processes for external parties to assess impartiality and fidelity to process requirements?
Well, we can start, Stephen, with just what kind of documentation there is in these files. And I notice Eben Lowenthal has kind of a similar question. Are accurate trial transcripts available for many cases that occurred in ancient history? As a practical matter, I've been fortunate. What I have discovered is that if a case was appealed, then pieces of the trial transcript tend to survive because they had to put things before the appellate court to kind of discuss whether they were legitimate or not. But in the case of John Snowden, actually, the Maryland archives couldn't find the pardon file. They looked really hard. They looked everywhere, but from the Glendenning administration, it's missing in action, which was a problem for me because I needed to see what the governor had actually seen, and I wasn't able to do that. Stephen, I think that they certainly could do a better job of archiving this sort of thing. But I think that as a practical matter, the courts are so backed up with so much work, and you wait so long for adjudication that I don't anticipate much of a change in procedures in the short term.
And Jean Demund, can you talk a bit about how you conduct your research? For example, are many documents digitized, or are you in archives with originals?
Well, when I was writing this, we were really already in the pandemic, so I wasn't able to go to archives or libraries even. But Gene, I was very fortunate. First of all, the Maryland State Archives knows a lot about the John Snowden trial, and they had actually digitized all of the records that they had that date back to 1917 and 1918 when the trial was going on. And they were online, most of them. So I was able to get them very easily. The other thing that informs most of my books is the newspaper archive. And I have to tell you, Gene, if you're doing research on American history, there are several websites, including the free one by the Library of Congress called the chroniclingamerica.com. Archive of old out of copyright newspapers from the beginning of the American Republic till basically the middle of the 20th century. And what's more, they are keyword searchable. So that, and I can't tell you what an incredible advance that is technologically. In the old days, we would go to the library and look at microfilm readers until we were blue in the face and hope we were going to find what we were looking for. With keyword search, you find what you didn't know you were looking for, and it's instantaneous. So the truth is, most of the research for this book I did sitting exactly where I am right now in this chair. I did have to write for a few records here and there when I couldn't find them online. And as a practical matter, most of these old cases are not online and probably won't ever be. There has to be some interest in it before anybody's going to go to the trouble of scanning it and posting it online. But I was fortunate with John Snowden because it was well trodden. A lot of people knew about this case, and obviously it was so important that people raised it again 80 years after he died.
Another one from the chat, Marilyn Maines says, were there any other suspects besides Snowden for the crime?
Well, there were a few, but they were fairly easily eliminated. Valentine Brandon himself was a suspect, but he had a really airtight alibi. Yeah, after he left for work that day, Lottie Mae was seen alive and well by several neighbors. By the time he got back, she was dead, and he could account for his time at work the entire day. He would not have been able to have come home and murdered his wife and gone back to work because it involved 2 ferry trips across the Severn River. So the police were pretty satisfied, and they also judged his affect, and he was pretty shaken up by her death. So they judged that he was in fact not guilty. There were other people that they looked at. Snowden himself at one point said he had seen some other black man in front of the house, and they wound up talking to him. But there was nobody that seemed as likely to have committed the crime, as far as the police were concerned, as John Snowden. And once the autopsy came back with skin of a black man under the fingernails, they pretty much figured out they had their man, and they stopped looking, which was actually one of the criticisms that was leveled at them, that they had stopped looking. They hadn't looked hard enough for somebody else.
Kind of along with that, Teresa says, Scott.
Sugamilli, yes.
Yeah, Sugamilli. Great presentation on another great book about a historical injustice, like the Third Degree. Of course, when you say Snowden had been seen outside the Brandon house, you meant that the sisters who glanced out the window claimed that it was him. In addition to the reward, as you say in the book, eyewitness testimony is extremely unreliable, especially under stress.
Yes, Glenn, you're absolutely right. This is Glenn Sugamilli. You're absolutely right. That is another thing that I don't know whether Governor Glendening took into consideration, but anybody who's looking at that case today should know that. Let me tell you what the women did, though. One of the women did not recognize him. The other sister did. She said, I think it's John Snowden. And the women the next day actually went down to the ice plant where he was employed to get a better look at him, and decided then that, yes, he was the man they had seen the day before. In fact, he was wearing the same clothing. But you're right, that is another factor, that eyewitness testimony is notoriously unreliable. And I know that was not taken into consideration in 1918 at the trial. Whether Governor Glendening took it into consideration, I don't know.
And then Alan Van Fleet, wonderful, Scott. Did you learn anything about other potential suspects? How was the woman murdered?
Well, I just talked about the other suspects. There were really very few of them, and nobody that really seemed very likely. She was murdered. She was strangled, but she also, what killed her was a blow to the head. She collapsed on the bed. There was blood, a lot of blood, but it was only directly below that wound. One of the cases that the defense tried to make was that she'd been murdered in the kitchen and she'd staggered to the bed. But the scientists made short work of that. The doctors made short work. They said she would have died instantly with a blow to the head as hard as that one was. And by the way, they never found a weapon that could have done it. The other thing that was interesting about the corpse was that there was evidence of sexual activity. There was semen on the corpse, but there was no evidence of penetration. And when they interrogated Valentine Brandon, he admitted that he had had intercourse with his wife the night before. He claimed that they had cleaned up after it, but it was not so cut and dried. And of course, there was no DNA evidence in those days. It was not so cut and dried that they felt they could claim that there had been rape. And also, since there had not been penetration, there had not technically been rape as far as the law back then was concerned. So I think that answers the question. How was she murdered? That's how she was murdered. But because of the presence of semen, the possibility of rape kept coming up in the trial, and the judge did a pretty bad job of suppressing it when it was mentioned. And again, I think that was highly prejudicial since the man wasn't charged with rape.
Thank you very much. And Julian, in the end, whatever the justice or injustice of the trial, do you think John Snowden was guilty?
And Karen Rothenberg has essentially the same question.
Yeah.
Based on your analysis, do you believe he was guilty beyond a reasonable doubt? I'm agnostic on that question. I certainly can't exonerate him based on all of that circumstantial evidence. And of course, you can convict for murder based on circumstantial evidence alone. It's done all the time. What I think is, and so basically the answer to that question is I don't know. But I think that given those circumstances, that the evidence was circumstantial and some of the other things that we talked about, I think the real burden here was on the governor of Maryland, not necessarily to release him, but to commute the sentence. I mean, clearly there was enough doubt about this that he should never have been hanged for the crime. But that's what happened. And I think it happened because it was Jim Crow Maryland and because he was a black man, and the governor gave himself away as a racist. So I really do think that's what happened.
Yeah. And then kind of piggybacking on one of the other ones, was the offering of rewards for information in murder cases a common occurrence in this era? $500 seems like a big chunk of change.
And actually, Harvey, there was $500 offered by the state, but there was also $500 offered by a Washington, D.C. newspaper that was really making a meal out of this trial. They saw it as a really great way to sell papers, and they made an offer of a reward as well. Interestingly enough, there is no evidence that the women ever claimed the $500 reward. And as a practical matter, they were pretty much drummed out of town. The Black community was furious at them for testifying against a Black man. And there was one particular preacher that was hateful to them because they did it. And both of them left town, and I don't know that either of them ever really returned at the end of the day. So they, as a practical matter, they had a lot to lose by fingering another Black man, but they did it anyway. But $500, I believe they possibly could have gotten $1,000, 500 from the state, 500 from the newspaper if they had sought the reward.
And then, are you aware of any opposition to the pursuit of a pardon for Mr. Snowden, or concerns of surviving family members of the prosecutors, judges, witnesses, or the victim that your research portrays the case, or that your research portrays the case unfairly?
You bet. I interviewed actually the great niece of Lottie Mae Brandon. She's unfortunately deceased now. And at the time of the pardon, she wrote to Governor Glendenning. She protested the pardon. She and also her another woman in her family who was just a straight niece of Lottie Mae Brandon. This was a great niece. She had several issues. First of all, she complained that the family had not been informed that the governor intended to issue the pardon. But she said that a pardon has an interpretation of innocence, and absent additional exculpatory evidence, you have no business issuing this pardon. I accuse you of doing it for political reasons. Now, the only thing she was wrong about is the interpretation of innocence. Pardons actually do not necessarily have an interpretation of innocence. Some people are pardoned because they are found to be innocent. That's true. But you've never had to be innocent to get a pardon. If they can find if you were abused by the police, if you didn't have a fair trial, those are also plenty of good reasons to have to do a pardon. But she accused him of politics, letting politics enter into it. And she was very articulate about it. And she was as passionate about it when it happened in 2001 as she was when I interviewed her about 2 or 3 years ago. So the answer is yes. And I think that what it underscores is that it's not cost-free sometimes for governors to do this. Sometimes they take heat for doing it. And this was an example of one where they did.
All right, that's the last of the Q&A questions. There is someone is asking, what are you working on next?
What am I working on next?
Yeah.
I'm doing this right now. I'm working on a new book that may or may not see the light of day. Most white authors write book proposals, and then once they find a publisher, they eventually write the book. I do it the stupid way. I write the book, and then I write the proposal based on it because I often don't know where I'm going with a book. And then we peddle it to publishers, and we see my agent sees if he can find somebody who wants to publish it. So this one doesn't have a publisher lined up, and I don't know if there will be one. But right now I'm working on a story that takes place in Manchuria in 1933. It was the kidnapping and murder of a young man in the Jewish community there. Yes, a lot of people didn't know there was a Jewish community in Manchuria, but there was. And how this played out when the Japanese invaded and when the war broke out. It basically was the exodus of the Jewish community from the city of Harbin. So it's a very different topic from what I've usually written about. And I'm not sure if it's any good yet, but I'll let you know.
Wonderful. Oh, well, thank you again, Scott. This has been fantastic.
Oh, it's my pleasure.
Yeah, definitely. And yeah, so many people giving you congratulatory remarks in the chat.
I wish I had time to see them.
Yeah, oh, whoops. Let's see. Yeah, so, oh man, there's Catherine Ilrick, Judy Bayer, Miriam Isaacs, Renee Weitzner. I'm seeing so Melanie Kirkpatrick, Alan Van Fleet, Karen Rothenberg. Ooh, there's like I could just keep going. There's a huge list right there. Robert Warden just said, "Yay, Scott." Gloria Gonzalez,
Well,
Micklin, yeah. So
thank you, folks. That's really great.
yeah, thank you so much, Scott. I appreciate you being on here, celebrating your book. It's been fantastic. I want to thank you all for joining us tonight on PMP Live. I did put the link in the chat a couple times, so please do click on that link to purchase a copy of Scott's book. And like he said, when you purchase it, make a note in the notes field that he said he would come in and sign it, because he will come in and sign. So we can even get him to personalize that if you'd like. So
thank everybody for coming tonight.
Yeah, absolutely. All right. So Scott, thank you very much. And everyone, thank you all for coming and celebrating with Scott tonight. So you all stay well and stay well read.